Turn now to the fourth case on this morning's docket. That is case number 103272, State of Kansas v. Drake Andrew Kettler, Jr.
If it please the court, I'm Nancy Ogle here on behalf of Drake Andrew Kettler, Jr., and I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Just as a way of, well, depending on what I'm able to cover during my oral argument, I just want to stress that any argument that is contained in the brief that I don't get to, we're not waiving, we just didn't have time to get to it. And I know you're very familiar with the facts of this case, and I wish I could just say what Mr. Whalen says goes twice for me and leave it at that. But I do want to remind you of some specific facts, just a couple specific facts regarding Mr. Kettler. When Mr. Phillips got the gun during the tussle in the bathroom and bedroom area of the house, Mr. Kettler was urging him and everyone else to get out of the house, made statements to the effect that we didn't come here for this and let's get out of here and so on. I'd also like to point out that it was Mr. Phillips who admitted to shooting J.D., the victim, and that it was Phillips and Armstrong who hit J.D. with the ashtray and so on. And Mr. Kettler did not do either of those things. In my brief, the first issue I raised, which was touched upon towards the end of the last argument regarding Mr. Armstrong, was the Batson challenges. And there were 3 African-American members of the panel who were struck by the state. And one of those, as has been mentioned in the last argument, was a woman who worked at a correctional facility, and the state's race-neutral reason for striking her was because she worked at that correctional facility and she might have come into contact or remembered one of the witnesses who, in the case, Ms. Stewart. That was jurors or panelist Sims. Neal was struck, according to the state, because he had unpaid traffic tickets, and therefore the state made the assumption that he's probably had a negative history with law enforcement. They also cited the fact that he was young and lacked education. And although I understand the challenge of the shifting of the state can make a race-neutral reason, but at least as to these 2 jury panelists, they are so thin that...
You mean someone who intentionally fails or refuses to follow the law by paying traffic tickets is someone the state would want on the jury? That seemed like a very good reason. If you have a scofflaw that's on the panel, I think as a prosecutor I would want that person off the panel. If they have no respect for the traffic laws, why would they have any respect for the laws that are trying to be enforced here?
Well, I would think that there's quite a difference between a traffic ticket and first-degree premeditated murder. But even going back to Juror Sims, just the fact that she worked at a place where someone else, one of the witnesses happened to be, and they may have come into contact or they may not have, But it's hard for a defendant, whether it's Kettler or anybody else, then to see into the reasons, of the state and come forward with a race-based, they can somehow prove what's in the mind of the prosecutor.
Well, how about the fact that there's 3 African-American prospective jurors, and all 3 are challenged through a peremptory challenge and struck? And that's it.
Right.
I mean, not that's it, and then the reasons given, at least on a couple of them, are speculative. And that provides a race-neutral basis to show no purposeful discrimination. But then you look at the overall picture. Do you have any cases that would lead us to, if it maybe the cumulative effect of the peremptory challenges
I'm sorry.
denying African Americans equal protection under the law to participate in our jury system?
Well, I totally agree that the end result of having a all-white jury, particularly in a case with 3 African-American defendants, would indicate that was a design by the state. I'm sorry that at this moment I can't cite a case to you that would support the statement you made.
Do I recall, I'm sorry, go ahead.
Go ahead.
Do I recall that the defense struck a couple of minority jurors?
I believe they did.
What's the difference here?
Well, the burden's on I'm sorry, but I can't remember the details of the African Americans who were struck by the defendants in order to answer your question more fully.
Were they African Americans struck by the defense?
I mean, according to the facts contained in my brief, I state that there were, and considering the size of the record in this case, I didn't go back and reread 58 volumes, but I don't recall the exact statements made regarding, for one, we don't have an ability at this point to review the reasons, because, the state doesn't say, well, why are you striking them? So we don't have a record that would tell us the reasons behind that. If there's no more questions about the Batson challenges, I'd like to move forward to the issue regarding the prosecutorial misconduct regarding the premeditation, and I know that was discussed in the last argument. But on behalf of my client, I feel the need to also bring this up and point out that the prosecutor said during his closing argument that essentially premeditation can take just half a second. And according to State v. Holmes, in that case, the prosecutor made a statement regarding how it can be instantaneously, but also stated that premeditation could take a second. There, the court reversed that, finding that the prosecutor had stepped over his bounds by making that statement, and it went beyond the latitude that's allowed during closing argument, as well as being inconsistent with substantial justice to mislead the jury into how much time is involved in, that can make a premeditation. And I do acknowledge that there are cases, and the law says there isn't a specific amount of time, but we have cases like Holmes that say that, you can't make it sound, there has to be a difference between something that's instantaneous and, as this prosecutor said, a second.
The coloring fact in Holmes, if I recall, was that during the instruction conference, they specifically talked about recent cases at that time, Moncla, I think, or whatever, and that instantaneous was improper. And the prosecutor went ahead and did it anyway. And so the way I read Holmes, there was an element of sanctioning the prosecutor for willfully violating what the trial court had instructed on arguments. So how does that play into this analysis? Because we don't have that scenario here, do we?
Not that I am aware of, we don't. But I would say that there weren't recent, there haven't been recent changes just prior to this, but we've had established cases like the Holmes case. So prosecutors are supposed to know the law. And even though he didn't, 10 minutes before agree to something else and come back out, I think the prosecutor has to be held to knowing what the law is, and that the fact that he can't say it's half a second and then have it be so counter to the fact that it can't be instantaneous. I don't know how many seconds we can, how to split up a second any further than that. I also want to point out, as far as, I only have 15 seconds, and rather than get into the discussion of the sufficiency of the evidence on the issues of premeditation, conspiracy, and aiding and abetting, I'll rely on the brief as filed.
Do we have any further questions of counsel? Thank you, counsel.
May it please the court, the state appears by Jody Litvin. I'll begin with the Batson challenges, and I have found some helpful language that goes towards the prosecution here, and it talks about the explanation not having to be one of persuasion. It doesn't have to be plausible. It doesn't even have to be...
Does it have to be plausible?
I believe that's what I cited from the case. It doesn't have to be one of persuasion. It does not have to be plausible. It's a very low, I could have misquoted that, but a very low standard, and I think that these race-neutral reasons, though not persuasive, did not need to be, and that they were facially valid. And again, once we provide that facially valid reason, the burden shifts back over to the defendant to show that there was purposeful discrimination.
Excuse me, counsel, the language you just quoted, is that from Batson itself?
I believe it was. I don't have the case over there. But
what are you reading from, your brief?
My notes that I took. I wrote it down from another piece of paper over there, and I think it was from Batson, but I didn't bring Batson with me today. I don't have it. I can follow up with that if you would like. The only other note that I had down here for striking youthful jurors was Mr. Williams struck youthful jurors. I do believe that some other African-American jurors were struck by the defendants, but I don't have those down. And in the brief, Mr. Kettler also argues that jurors with similar attributes who were not African-American jurors were struck or were not struck. And the record cites to several pages, but when I looked through the record at that point, I didn't see any specific names of non-African-American jurors that had similar attributes or anything in the brief that talked about those specific jurors that were kept on the panel that had the same attributes as the ones that the state struck.
I was curious about the same thing, so asked for those pages. And there was a reference to two jurors who were youthful, but it doesn't indicate that they had the similar issues about the traffic fines or low education that I could find.
Yeah, I don't think there was anything about lack of life experience. I mean, lack of life experience and being youthful was what was found. And also, the state does refer to other white jurors that it struck with similar attributes. I have down Juror Cowan was youthful, and Juror Hunnard had contact with the judicial system as a defendant in a case, and for similar reasons, we struck that juror. So I think that compares with the juror that had negative law enforcement by not paying his traffic tickets. To the prosecutorial misconduct issue, again, as I stated before, I don't think that his comment about half a second went outside the wide latitude afforded to the prosecutor. If we look at his closing in whole and in context, he talks about premeditation just having to be thought over beforehand. He makes several proper references to the definition of premeditation, and there was no evidence on the record that he deliberately misstated. And I think that's important because Holmes makes this specific holding that the prosecutor there talked about the fact that he knew that that was not the law. He made several statements to the district court that he knew that that language was improper and had been noted as improper by this court, and went on to say it anyway. So I think without that deliberate, purposeful
And so
aspect.
the prosecutor in this case was unfamiliar with Holmes, is that what you're saying?
I'm not sure if he was unfamiliar with Holmes, but there's no evidence on the record that there was a discussion between him and the trial court.
I understand that, but why can't we ascribe knowledge of Holmes and the other cases to every prosecutor?
I think that's fair to say that prosecutors should know that you cannot say that premeditation can occur in an instant or is instantaneous, and that they should know that that language has been disapproved by this court. And I don't think that the prosecutor said that in this case.
In this case, Mr. Kettler is challenging the sufficiency of the evidence, specifically with regard to premeditation. Mm-hmm. Does that have any bearing on the impact of the statement if we do find it was an improper statement of premeditation?
I don't think so, because that's not the focus of his argument. He states several times that the premeditation occurred long before, when they were driving over to Rhonda Shaw's house, that they had had discussions. He references Armstrong's testimony that talks about, we planned this, we talked about it ever since the night that the robbery occurred, that the victim was robbed. We knew what our intentions were, and that evidence goes to support premeditation. So I think he talks about the evidence in premeditation as being thought about long beforehand, and not just that brief reference to it can be formed half a second before.
With respect to the sufficiency of the evidence of the conspiracy, does the state have to prove that there was explicit interaction and discussion, or can you have a conspiracy by implied agreement?
I believe you can have a conspiracy by implied. I don't believe it has to be direct and explicit. Although I think Armstrong's testimony, or his sworn statement that was admitted, presents that there was evidence that it was an explicit plan, and that they came over the moment after Mr. Williams was robbed, him and Mr. Kettler, and they talked about this plan of getting JD, they were going to get the victim, and that they knew what they were going to do from that moment. I also think it's important that Armstrong said, we knew what the goal was before we got into that house, and that goal was to kill JD. So I think they had premeditation. I think they had thought about it long beforehand. And I think that robbery happened, I believe it was several weeks prior. I don't know that we pinpointed down a time, but at least several weeks prior to the killing in this case. Additionally, if we look at the timeline, that infers premeditation. This all happened very quickly. A phone call was made. They found JD. The car shows up, they all get in, phone call was made to Rhonda Shaw's house to confirm, they quickly get over there, and the shooting occurs. So I think that also infers premeditation, that they were all on the same page, they knew what was going to go down, they had the weapon, and they were going to get JD. And if there are no other questions?
Any further questions of counsel? Thank you, counsel.
Your Honor.
Thank you. One thing that I wanted to clarify, and surely you all understood that when counsel answered a question, she was saying, Kettler said so-and-so. Well, Kettler has not said anything and didn't testify. I mean, later in her argument, I think it became clear that she was referring to statements by Armstrong, and I just want to make clear that neither in his brief or trial or any other statement did Mr. Kettler say, we planned this, this is what we were going to do. And I just wanted to clarify that. Unless the court has specific questions, I would leave, since we have covered, there weren't questions beyond what I had discussed in the first time I was up here. If you want me to address in the short time I have the sufficiency of the evidence, but primarily I want to remind you that it was Kettler that once he was in the house was trying to get them back out of the house and saying that this wasn't what we came here for.
And that evidence was presented to the jury?
Yes, it was, through the
So what do we
testimony.
do with it? I mean, we don't weigh that or determine the credibility of that, so
Right.
how was there a failure of proof of the premeditation, conspiracy, and aiding and abetting?
Well, although I realize that this court cannot reweigh the evidence, really the only testimony or evidence that was presented that supported much of what apparently the convictions are based on are statements by Armstrong, who contradicted himself several times. Then when he testified at trial, he said he was uncooperative with the state, even though he was the state's witness. He testified through a spit mask and was finally removed from the courtroom because he was so combative. And I know you cannot reweigh what the evidence presented, but I think under those circumstances, those are the facts of Mr. Armstrong. And I think you can look at his testimony, the evidence presented without reweighing it, but recognizing what those facts are. Any other questions?
Any more questions of counsel? Thank you, counsel. Thank you both counsel for your arguments this morning. Court will take this matter under advisement.